Very good morning, my dear friends. In today's session, we'll deal with the different special types of customers. We have been discussing about the bankers and customer relationship. In this context, we have discussed about definition of banker and then rights, duties, Clayton's rule, and then the customer's definition that was completed earlier. And then in today's session, friends, we will deal with how different types of customer accounts are maintained in a bank. Because there are special types of customers. Customers' definition has been discussed already. But what is important here is that what are the special types of customers who are admitted in banking operations and how these operations are carried. So, friends, the first type of customers is very interesting to note. They happen to be minors. So, minor is, of course, naturally, needless to say, is a person who has not completed 18 years of age and he is not competent to enter into any contractual obligations under the Indian Contract Act, Section 10, read with 11 and 12 of the Indian Contract Act. However, the bankers can permit a minor to open an account as per the norms of the bank. In fact, earlier it was 15 years, now I think even up to 12 years and above, the minors can be admitted as, in fact, operating customers. I remember in my childhood, after completing age of 15, I requested my dad to open an account for me. Then I started taking my pocket money putting into the bank and again withdrawing. And then finally I have withdrawn and withdrawn and withdrawn everything. Then the banker said, in those days, it was only 5 rupees, the minimum balance used to be. And then my banker said, Sir, Babu, below 5 rupees, you can't. In fact, I don't permit you. Minimum balance has to be kept thereon. So minors used to, in fact, operate banking operations. And then in fact, with the court order, with the huge properties in the name of the minor, a banker can open an account for him also. Due to the stringent law in protection of minor, the banker must be very careful in dealing with the minor's account. Then the prudent banking practice warrants that the banker can open an account in the name of a minor, but it should be operated by the natural guardian or any guardian appointed by the court or a testamentary guardian. This is the way the minor can be dealt with. If the minor is above the age of 12 years, as the rule now, the present banking practice permits the minor to operate the accounts by himself. Earlier it was 15, as I told you, I was operating. But the savings bank account alone is permitted to be operated, not other banks. And friends, two minors can open a joint account also, but the ultimate responsibility falls on the guardian, court appointed or the natural guardian. The guardian implies here a father or on his demise the mother. That is how the law comes into picture. The Supreme Court, however, in Gita Hariharan and another verses, Reserve Bank of India and another. This was reported in 1999 to SCC 288. The Supreme Court in this case held that the mother can also act as a natural guardian of a Hindu minor even during the lifetime of the father, and under certain extraordinary circumstances where father cannot, in fact, move out or is not in a position to operate. A minor may draw, endorse, or negotiate the negotiable instruments, but he would not be held liable. That is the most important aspect. Regarding the liability of a minor, the provisions of the Indian Contract Act and the provisions under Section 65 relating to supply of necessities would apply to a minor as they are taken under the quasi-contractual obligations under the Indian Contract Act, Section 65. Now, friends, the second category of customers, special types of customers, happen to be illiterates. Here, illiterates means customers who cannot read and write, they cannot sign. The bankers can permit them with thumb impression, and proper care, of course, has to be taken regarding their identity and permitting them. Then, friends, the third one happens to be the trusts, where the trusts are created. Then the banker must examine the trust deed, and according to the terms of the trust deed, the operations can be permitted, and it must be taken as to who would operate the bank accounts of the trust, as the trust deed is the basis of the trust, and it speaks about the persons competent to operate the bank accounts of the trust. Even attorneys can open. The fourth category, attorneys, can also open bank accounts through their power of attorney holder. In fact, a customer can operate a bank account through the power of attorney also. That's how we call them as attorneys. The power of attorney is governed under the Indian Contract Act, law of agency, simple. And also the Powers of Attorney Act 1882, both are enactments. And the formalities on the granting of power must be complied with in accordance with the legislations and also the Indian Stamp Act 1899. These are all the precautions supposed to be taken by the banker with regard to a customer being represented by power of attorney. Now, the next fifth special type of account happens to be the partnership firms. The partnership firm is to be operated under the Indian Partnership Act, read with the Indian Contract Act. It shall be in accordance with the partnership deed, of course, and the banker will act as per this deed, and also the letter or mandate submitted by the partners of the firm. Then the partnership firm is governed under the provisions of the Indian Partnership Act and also the Indian Contract Act, as I told you. Then it depends upon the mandate given by the partners to the banker thereon. Then, friends, the sixth point is the corporate clients, the companies. Obviously, the companies are governed by the either Companies Act 1956 or 2013 or any previous company legislation under which the company has been registered. And then the companies are naturally regulated by the memorandum and articles of association. And the banker must allow the operations by a company only in accordance with the provisions of the memorandum and articles, and the board resolution also required to open an account by a company in the bank, and the operations of borrowings, etc., are stipulated in the articles of association. It must be followed by a board resolution also. And the banker should ensure that in the company transactions, he does not commit any ultra-virus act, that is, act against the objective clause of memorandum of association or an act beyond the powers granted by the articles of association. Another important aspect is the managing director is concerned. He is a statutory, in fact, representative of the company. The reason being he is named in the provisions of the Companies Act, but not others. So if a general manager is operating and others, board resolution is a must. Now the next point is the seventh one, the seventh type of account, the joint Hindu family. A joint Hindu family is one which possesses properties from the ancestors and also carries ancestral business. So a joint Hindu family is governed by the Hindu law, and then the family business and the assets are managed by the Karta, called our manager. And the Karta or the manager can operate, and then he has to fulfill the KYC norms. And then in case of any disputes of co-partners, the bank accounts will be operated either by the original karta as per the orders of court of law or any other person, as the case may be, if the matter is taken to court, or the original karta proving his identity, the banks can operate. Normally, the banks will say, dispute comes, go to court. So it is for the court of law to decide ultimately these matters, resolve the disputes. Now, the eighth one is the charitable institutions, clubs and societies. They are all bounded by the bylaws, and according to their charter or the bylaws, the operations of bank could be taken into account, and then accordingly the banker will take appropriate steps thereon. Now, the most important aspect under 9 is the executors and administrators of wills. The administrators, executors are normally named nowadays in the wills. Now it has become a very good, practice of lawyers now to draft the will in that way. And they can, in fact, realize the assets and pay off the debts of the deceased person, and they can operate the bank accounts also as per the will or letter of administration issued by the court of law. If the court gives an order, then it is binding on the bankers. Then another important aspect is with regard to joint accounts. Joint account means two or more persons can jointly hold a bank account and operate either or survivor, any of them or any two of them or all of them. The joint account may be operated here jointly, as I told you, either or survivor or the former or the survivor of them. It all depends upon the mandate and the legal effect, in fact, of a joint holder and the devolution of joint rights in case of death of any of the joint holders are enumerated under Section 45. Section 45 of the Indian Contract Act 1872. Then, friends, another most important thing, lunatics. Whether lunatics can be represented in banking operations. Section 10, 11 and 12 of the Indian Contract Act 1872 deal with this subject matter. Obviously, the next friend can operate. If a court of law appoints any administrator of the properties of the lunatic, then he would run the bank accounts. In case a banker receives any authenticated information that a holder has become, in fact, turned insane, then he will suspend all banking operations until it is proved that the account holder is sane for safety purpose, or he will seek intervention of court of law and he will follow the orders of the court. Now, the last two categories left out, that is 12th one, is the husband and wife. Whether husband and wife are independent for the purpose of operating bank accounts or whether they have any liability. Prima facie, woman is a family in India. And woman can operate independently on her own bank account, so is the case with husband. And if they are even having, in fact, joint accounts, they are not liable for each other's debts unless they stand as guarantors for each other. This is the most important aspect. And then they are absolutely independent for the purpose of operating bank accounts in their individual names. So far the joint accounts are concerned, then the question comes as to the liability. They are not liable for each other's debts unless they stand as guarantors. The last point is, friends, on Pardanashin women, where the woman's identity cannot be found because the face is covered. This is the 13th type of special accounts. This face is covered and not shown to the banker. These persons maintain total seclusion. So the bankers will normally stipulate their own rules permitting Pardanashi women, but they are also permitted, and then their signatures will be verified and it will be subject. Today, verification process has become more easy with IT technology, Information Technology Act, and then the computer, in fact, boom. So the norms are stipulated by the banks and appropriate care will be taken in that regard. So, with this background, friends, we close our discussion on the special type of accounts which customers can maintain. In our next session, we will deal with the rights of the customers, and especially under the Consumer Protection Act. And lastly, I will deal with the banking ombudsman with regard to the customers, and then close our discussion with that bankers and customers relationship. So, thank you, my dear friends, and then we will meet again for the rights of the customers. Good day and goodbye. Thank you.